Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So to introduce our speakers today, Justice Chin joined ADR Services, Inc. in 2021 after a highly decorated and illustrious career marked by exemplary public service, including 24 years as an Associate Justice of the California Supreme Court. He is deeply respected and admired among his peers, not only for his remarkable intellect and strength of character, but also for his great dedication and contributions to the California judiciary and the legal community at large. As a mediator, arbitrator, referee, and appellate consultant with ADR Services, Inc., Justice Chin continues to serve the business and legal communities by resolving complex and divisive matters through alternative dispute resolution. And we also have Justice James Lambden with us today. Since becoming a full-time neutral with ADR Services, Inc. in 2013, Justice Lambden has engaged in complex dispute resolution and has served as a mediator, arbitrator, referee, mock arbitrator, and appellate consultant in disputes ranging across the breadth of civil disputes. Justice Lambden brings to his ADR practice nearly 4 decades of experience as a trial lawyer, trial court judge, and associate justice of the California Court of Appeal. During his 14 years as a trial lawyer, he represented clients throughout the state in cases involving construction, commercial contracts, torts, secure transactions, employment, insurance, and real estate. His clients ranged from wind farms and startups to international corporations such as Maersk and Co. His 7 years as a trial judge included more than 4 years presiding over a master civil calendar and motion calendaring calendar averaging 25 to 30 hearings each day. During his assignment, he also briefed the presiding judge weekly regarding the settlement prospects of the cases coming up for trial. In his other civil assignments, he managed the fast track calendar and successfully settled dozens of cases scheduled for jury trials and tried to verdict many others. So thank you both very much for joining us today, and I will hand it over to you, Justice Lambden and Justice Chin.
Thank you, Katie, for that generous introduction. I would point out that this presentation was originally presented when the rules came out 3 years ago without the assistance of my colleague, Justice Chin, and I'm delighted to have him join me. I think Katie shortchanged my decades just a little bit, but I would point out that between us, Justice Chin and I have probably over 100 years of experience in this area. And we have both been heavily involved in the committee work of the Judicial Council, which resulted in these rule changes. So I'm looking forward very much to hearing Justice Chin's take on the behind the scenes or otherwise approval of the new rules. As you can see in this first slide, if you want to hit that, Katie. The changes were a long time coming, and as we discuss them, you'll begin to discern the reasons, because there have been considerable changes in the approach as policy matters to the rules. Most importantly, that there are new reporting responsibilities, and that expansion was one reason that it was so carefully considered over such a long period of time. As you can see, these materials are going to be very dense. California was the last of the states to approve the adoption of the model rules of the American Bar Association, but there are some important differences in the California rules. And those differences largely revolve around policy changes that we're going to be focusing on. Your questions and comments are going to be welcome and will be collected as Katie indicated. We will try to respond to those later, and we have found those to be very helpful in focusing our presentations. So you will be heard, even though it may be difficult for us to do it today under the circumstances because we have so many attendees. Even though the materials are dense, with our comments, we will suggest that the hypotheticals will be able to serve as thought exercises for you even after today, and you should consider carefully the pivot to additional responsibilities that we will be discussing. I think we can go to the next slide, Katie. Throughout our careers, we were involved with the state bar committees and the judicial council standing committees that were engaged in these policy ethical issues. We both had close connections with the long, and I underline that, long standing committee that worked for 29 years on the revisions of the rules that we'll be discussing today. One of my observations during the entire stretch of time that that I've been working on these rules has been to focus on the fundamental policies of the attorney-client relationship, which I have described as the 3 C's, which we'll discuss in a little bit of detail in a minute. And those include first, confidentiality, because the client comes first on that. Second, competence, so that you know what you're saying when you advise your clients and do so in a competent fashion. And finally, compliance, which would be compliance with the literal ethical rules. Justice Chin, do you have any comments on the discussion that was undertaken with reference to the final approval of the rules by the Supreme Court?
Well, Justice Lambden, your comment that we have 100 years of experience kind of threw me for a loop, but you're absolutely right. We've been doing this for a long time, but during the past 100 years, the practice of law has changed drastically. It has grown exponentially. The growth affects not only litigants, but all citizens in the state. It affects them both economically and jurisprudentially. Historically, though, California was the only state that did not track the ABA model rules in its ethics requirements. Until 1989, when then California Governor George Deukmejian signed into law Senate Bill 905, the continuing legal education bill. The idea behind the bill was to require attorneys to continue to study important ethical concerns as part of their legal practices. The reason was so that they could gain increased awareness of ethical principles that are integral to our law practices. And as you say, Jim, confidentiality, competence, compliance were the guiding principles behind the rules when Senate Bill 905 was added to the Business and Professions Code. That section mandates that at least 25 legal education hours be required, and 4 of those in legal ethics. In 1989, the legislature required that the state bar request the Supreme Court adopt a rule of court authorizing the state bar to establish and administer an MCLE program. On December 7th, 1990, the court adopted 9.31, the provisional legislation that authorized the state bar to adopt more detailed rules. In late 1990, the board approved the MCL rules and regulations, and the MCLE program was launched in February of 1992. At the beginning of the 21st century, seems like we're talking about 100 years a lot here, the number of lawyers in the state has increased dramatically over the previous century. Coupled with a rise in the number of lawyers was a substantial increase in the lawyers statewide who engaged in multi-jurisdictional practices. Chief Justice decided that the rules needed greater uniformity and national consistency, both in practice and application. The need for greater consumer protection and a logical set of rules provided the catalyst for the change. And as you all know, the first commission the chief appointed worked on revising the original rules for many years, only to see the proposed rules rejected in 2014. As you know, the second commission was appointed and it was given a 3-year deadline to complete its work. The court, in making the request for the commission, wanted the rules consistent with the ABA model rules, not a copy of them, but consistent with them. Those rules were adopted in 1993 to provide practitioners and courts with a set of ethical rules based on national policies that were clearly written, broadly applicable, and relatively easy to interpret. Now, the second commission did not adopt the rules verbatim. They did use the numbering so that they would at least be consistent. But I spoke recently with the chair of the commission, Justice Lee Smalley Edmund from the Second District Court of Appeal. And she said that the ABA rules were not adopted verbatim because of the history behind ethics in California. And we also had a substantial body of case law. So they are nuanced and they have to be looked at carefully. Now, fortunately, the first, I think 27 of the proposed amendments were adopted, but 42 were redrafted over several years and were finally completed in 2018, which Lee Smalley Edmund reminded me was exactly 3 years from her appointment. The new rules took effect in November of that year and were the largest comprehensive set of rule changes in over 29 years. The rules continue to figure prominently in the State Bar's MCLE programs.
Are we ready for the next one?
Yes.
I would follow up on one of Justice Chin's comments that Justice Edmund pointed out, is that we will discuss at least one rule that was rejected regarding diminished capacity of clients. In terms of the most recent opinion issued by the Committee on Professional Responsibility, which essentially concluded that California's state law was robust enough to do without the rule pertaining to clients with diminished capacity. And we'll get back to that in a minute. Justice Chen was careful to point out all the changes, and I will only highlight a couple with reference to the 42 rules. The court, as I've said, entirely rejected one proposed rule in line with Justice Lee Edmund's comments about our state law. And you'll see as we discuss it later that it is a very thorny question that involves the question of what a lawyer can do and cannot do with reference to representing a client with diminished capacity. The case that resulted in the opinion that we'll talk about later was one where a personal injury plaintiff who was able to settle his case was expecting that his traumatic brain injury would worsen over time and attempted to give his attorney in the case essentially attorney in fact and de jure responsibility in the event that he was unable to make his own decisions. Obviously, there are a lot of landmines in that sort of arrangement, and we'll discuss the opinion that discusses the answer to that question. The new rules have now been in place for 2 years. because of the 3-year MCLE cycle, it's likely that some of you haven't heard about the new one. So we are going to go through that. But our focus is going to be on the major changes in terms of policy and enforcement. I think it's worth commenting too that our colleagues, Justices Woolard and McBride, will be presenting another 2-hour segment regarding ethics that'll be available to you that focuses on the enforcement part. But we're going first so that you'll have an opportunity to read the rules before you get subjected to enforcement. So I'm happy to say that you might want to watch that second set later. In the years following the approval, the Committee on Professional Responsibility has issued, I think at this point, 7 formal opinions, maybe 9. All of those can be found on the link that is going to be shown in this PowerPoint. And it's useful that you go back and actually read those opinions. We'll discuss them, but there are some very interesting comments in those opinions, and they're very well thought out. It's something that you should put on your to-do list every year to keep track of those opinions in case you haven't heard of them. One revision in the rules that is fairly easy to deal with is Rule 5.2 at the bottom of the slide here, which basically clarifies the duties of subordinate attorneys, and that is a major change in clarification. Another change that I will mention just in passing is a definition, a better definition of what a person is with reference to the rules. Justice Chin, do you remember the formerly arcane rules or different rules regarding who's a person and who this apply to?
Well, that's an interesting question, Jim. Talking about arcane, many of the former laws defined person as simply human, remarkable, or in some legal dictionaries as a man considered according to his rank in society, according to his rank he holds in society, with all the rights to which the place he holds entitles him, and the duties would impose. Oh, come on. Corporations were eventually included as artificial humans. We've come a long way since those arcane definitions appeared in the law. The most recent definition of persons in Rule 1.0.1 is quite broad. It says person has the same meaning as in the Evidence Code, Section 175. It's defined as, quote, a natural person, firm, association, organization, partnership, business trust, corporation, limited liability company, or public entity. Thus, the rules cover a lot of the lawyer-client relationships. I agree with you that we cannot overstate the significance of the new rules. They brought about a sea change in how lawyers must treat clients, from requiring strict client confidentiality to setting guidelines for private relationships between attorneys and clients. Reporting rules are now strictly enforced and are meant to discourage harassment, bias, discrimination in all aspects of the profession. The conduct of the rules prohibit, the conduct that the rules do prohibit is given equal status to the conduct of the rules encourage, and call lawyers to task if they take advantage of clients' vulnerabilities and weaknesses. Most importantly, the rules encourage the professional responsibility that lies at the crux of our important work. As you point out, Jim, Rule 8.4.1 prohibits discrimination and retaliation in client representation or termination. And it was hotly debated because it requires all lawyers to notify the state bar of workplace unfairness and notify the DFHA and the federal agencies if those lawyers suffer a disciplinary action. In other words, if they are notified of a disciplinary action, these agencies must be notified. The reason is that violations of Rule 8.4.1 have severe ramifications. This is quite a change from the original rules. The new rules prohibit law firms from knowingly engaging in discriminatory hiring, firing, training, and compensation decisions. What this means is that a lawyer or a law firm violates the rule if they fail to advocate for corrective action. The new parameters are more expansive than the predecessor rule and essentially prohibit discrimination based on medical, marriage, genetic, veteran status, just to name a few categories. There are many, many more, and if you're interested in the details, please read the rule. Under the former rule, the state bar could initiate a disciplinary proceeding could not initiate a disciplinary proceeding until a tribunal of competent jurisdiction determined that the conduct had occurred. Even then, the bar's finding was only admissible evidence in the disciplinary proceeding. The bar could not discipline the offending attorney or firm until a finding of misconduct in the other tribunal had become final. Of course, the brief list that I gave you is not all inclusive. So let's just say that any form of lawyer or law firm discrimination is prohibited under 8.4.1. There's some concern that the broad rule reaches too far into gray areas, even courtroom behavior. While it is true that the rule prohibits an attorney from demonstrating bias or prejudice in the courtroom, does not expand to motions or other evidence that is protected by the First Amendment. I think we're ready for slide number 5.
Before we start, let me repeat what the point is here, is that formerly there could be a time delay and there had to be a wait for for some other regulatory agency to make a decision before the investigation would begin. Now it begins immediately. Secondly, everybody has a responsibility within their own office and within the courts and elsewhere to observe workplace fairness and workplace compliance with the law regarding discrimination. And in addition to every attorney having to report that, it includes subordinate attorneys. So let's take a look at this hypothetical that is on the slide now. Lawyer discovers that her firm has an unspoken but obvious policy against hiring a particular minority. The firm, there's a misprint there, also has an obvious unspoken policy to never represent that minority. The lawyer has also observed a senior attorney has serial questionable liaisons and relationships with staff members, and he behaves inappropriately with clients. Considering the fact that you have to report your colleagues for that sort of behavior, where does that leave us with reference to our new duties? I think Justice Chin has made clear that we really can't overstate the significance of that change. And also that was one of the reasons that the scope of Rule 8.4.1 was one of the most debated provisions in the rules. I think it goes without saying that we can expect to see additional opinions issued in this area because it is potentially extremely, I guess, extremely controversial. So one last thing, comments, Justice Chen, on how Rule 5.2, which now eliminates the I was just following orders rule, and also goes further and says the subordinate attorney has to say something or see something and say something. What is your view of how far that may go?
Well, rules 5.1 and 2 clarify a subordinate's duty to speak up and to use their independent judgment when they learn that a supervisor has violated the rules.
So let's go to the next slide, Katie, if you can. Yeah, so in your own practice, think about what this may mean in terms of where we have come. Now, coincidentally, the 29-year hiatus here that involved this particular rule goes back to a period that all of us older attorneys remember, I think, when we heard about the case of Weeks versus Baker, Baker McKenzie. I've forgotten the date of that now, but it's been probably the early 90s. Justice Chin, with reference to that, do you think there was an influence from that Weeks versus Baker McKenzie case that initiated some of the discussion here? I see now that it was 1994.
Yes, Jim, it was before this rule. So let's go back. We'll talk about Weeks, and we can tease out what might have happened if that occurred after these rules went into effect. Under Rule 5.1, managing or supervising lawyers have a duty to make reasonable efforts to ensure that the firm has reasonable measures to provide assurance that all lawyers in the firm comply with these rules and the State Bar Act. Under point 2, a subordinate lawyer has an equal duty to comply with rules and is now unable to plead that they were just following orders. This is a far cry from the former rules that simply imposed on managers and supervisors the duty to supervise subordinates. We refer to discrimination and referred to discrimination in harassment in rules 8.4.1 and 5.1 and 5.2 as the as Jim said, see something, say something. They call for the exercise of independent judgment and require subordinates to report unprofessional behavior. As Jim mentioned, the blockbuster case in 1994 was Weeks versus Baker McKenzie. It preceded the rule changes. It produced the largest punitive damage award at the time against an established law firm due to a partner's consistent sexual harassment of subordinate employees. A plaintiff was a paralegal in the firm. Was awarded $50,000 in compensatory damages for emotional distress as a result of the harassment. The attorney's behavior included crude remarks, innuendo, vulgar notes, inappropriate groping. The jury, incidentally, was composed of an equal number of men and women, found that the law firm knew the attorney about the attorney's harassing behavior and failed to stop it, even though the firm was aware there had been numerous previous complaints by former subordinate employees. The second phase of the trial, the jury awarded plaintiff $6.9 million in punitive damages. It was the highest of any at that time. Also $225,000 against the attorney. The attorney was dismissed from the firm in the middle of the suit. Incidentally, he was allowed to continue practice as a solo practitioner after the lawsuit. I would guess that similar behavior today might lead to disbarment. Let's suppose the similar behavior took place 3 years ago when the rules became effective. I would hope that any law firm would take immediate action against the offending supervisor in order to minimize damage to the employee and to prevent the same behavior from injuring other employees. If not, under the new rules, we might see a class action with substantial compensatory damages in addition to millions in punitive damages awarded, and you can only imagine what a jury would do with that evidence now. What about the supervising attorneys who witnessed the poor behavior but failed to report it? This presents the subordinate employee with a conundrum. If they clearly witness the supervisor's harassing behavior, they must report it under Rule 5.2. They cannot say that they were silent because the partners told them to be. However, there is an ethical question that may be answered reasonably in two ways. Is it permissible to follow the supervising lawyer's direction? If the supervising lawyer's answer would violate an ethical violation, the subordinate lawyer must express a contrary opinion. So we wanted to take a look at weeks as it occurred, and we wanted to take a look at weeks based upon the current rule.
I think the takeaway is also that the new rule benefits the firm and the other members and equity owners of the firm, because the entire firm can be subjected to potential liability for both the supervising attorney and conceivably for the subordinate attorney who saw what happened and was an accessory after the fact, sort of. So this rule, or rather the Weeks case, occurred when both Justice Chin and I were already on the bench. But I imagine that a ripple went through the entire bar practice out there, similar to the one that occurred a few years earlier when the case came out that said that there was dram house liability for holiday parties, where you could get in trouble for the associate who ran over somebody on the way home with too much to drink at the holiday party. This is worse than that because it can implicate an entire firm and places the responsibility clearly on everybody to speak up. And you don't have to wait till somebody files a lawsuit or a complaint with other authorities. So this is a major change and one that, as you can imagine, as we go through some more hypotheticals, this will also affect these additional hypotheticals in a way that will put a lot of conflicting interest in law firms, particularly between subordinate attorneys and their supervisors. Let's try the next slide. These aren't the only thorny issues that were raised, but let's take a quick minute to shoot through some of the opinions that have come out since the new rules went into effect. These come out every year. They're put out by the Committee on Professional Responsibility. People take great care in preparing these opinions, and actually I find them to be very well written and very well thought out. So you should consider these to be the source, including a couple that I'll mention that aren't in this slide, that are the most recent. So it's a good idea to look at these in their original form, but I'll kind of summarize them real quickly. You've got new ethical obligations with reference to funding by third-party litigation funders. And you will all appreciate that there's a budding industry there that's been around for a long time where people invest in lawsuits. But there are considerable conflict of interest and confidentiality issues that are presented by that. You may have the possibility of how do you maintain the confidentiality of that with reference to an investor who is looking over the shoulder of the attorneys, whether or not there may be undue influence of some sort on the case with reference to the investors, quote unquote, in the case. Whether or not the competence of the attorneys handling the case, including others that might be involved as investors, is implicated. And also who negotiates the contract for the funding? Is it the same attorney or is it a different attorney? And if it's a different attorney, what does that mean? So I would just urge you in this one in particular, as in to the others, you need to really kind of read that and see what your responsibilities are going to be if you're engaged in any of those. The opinion number 203 from 2020 discusses further the perennial problem of hitting send all and sending electronic data. You know, we've all heard of the horror stories of hitting the send button and you just sent your entire evidence file to the other side by mistake, or you've waived confidentiality by disclosing something. Those can be devastating. And even though we have robust rules and discussions about how you deal with that and immediately disclose it and immediately recover it, it can produce considerable problems even when those remedial effects are undertaken. For example, somebody can make a motion to have you dismissed from the case. So in a large case, which is one where this may occur actually in terms of evidence, you may get yourself in real hot water on that. 201 deals with what happens when a lawyer departs the firm. Again, it stresses one of our 3 C's, the client's interests come first. So if you read that opinion, what it really points out is that each client's interests have priority over the interests of both the lawyer who's leaving and the law firm she's leaving. Opinion 200 discusses 3 issues, which we're going to discuss in further detail later in our presentation. But you can get a preview from this slide to think about as we go forward when we reach our final discussion. So what happens when, these are issues, by the way, that have been around for over 100 years, I'm very sure, but what must the
That's not mine.
No, that is mine. I very much apologize. My cell phone is in my pocket. There you go. I'm sorry. So what does the attorney have to do when the attorney suspects that a witness in a civil trial has testified falsely? And number 2, what are the duties when the civil attorney doesn't suspect but knows that the witness has committed perjury? And 3, what if the attorney first learns of the perjury after the witness has testified at trial? And an extra kicker, the client has adamantly instructed the attorney not to continue to use his to continue to use the perjured testimony, or or basically has threatened to fire the attorney. That obviously produces real problems for an attorney, and we'll come back to that in a minute. A kind of related issue would be the situation where an attorney needs to withdraw because the client's case, and there's a misprint there too, lacks merit. Can the attorney go ahead and settle the case before withdrawing, or must something else be done? You need to look at that opinion, because that is something that has come up in some of my mediations and has troubled the attorneys. And you need to consider that if you find yourself in a situation where you're really at odds with your client over whether or not the case lacks merit. That can be related, of course, to the question of whether or not the client is telling the truth. So finally, in all of these, it may become necessary for your firm to consult an attorney regarding some of these legal issues with reference to, of course, ethical compliance and possible malpractice. So how do the obligations change if you hire another lawyer or you consult another lawyer in the firm regarding a potential compliance issue or a potential malpractice issue, maybe the firm's own in-house counsel, or what happens when you consult somebody outside, and how does that affect the client's interest? One more time, the takeaway, of course, is that you have to consider the client's interest first. Another one that we'll discuss, there are a couple of others that we will discuss in another context. One is Rule 202, or excuse me, Opinion 202, which makes clear that lawyers can, under some circumstances, most circumstances, represent clients who are engaged in the cannabis business, and the limitations there are fairly clear. Shall we go to the next opinion, next slide? Well, sometimes we say, well, of course, and that is, in most circumstances, lawyers should not have sex with their clients. That's, I think, a pretty good piece of advice. However, that's easier said than done, because there are some circumstances which have to be taken care of. For example, what if you're representing your spouse in a case, or there's a reluctance to intervene with a per se rule that it can never happen. So there was considerable discussion over this. All the way back in 1987, opinion number 92 pointed out a lot of problems with the former rule, which simply said a client should not have sex with a client only if the act was coerced or if it was considered a form of payment for services. The 1987 opinion pointed out the limitations of that rule, and that led to this long discussion over whether per se ban was appropriate. Justice Chin, do you have any comments on that process? I don't know if the court discussed it at great length, but I suspect that since sex is always interesting to everybody, maybe you guys have a particular memory of what the discussion was on this rule.
Well, Jim, the new rule 1.8.10 prohibits lawyer-client sexual relations unless there was a pre-existing consensual relationship. The new rule represents a change from the way the state bar used to approach lawyer-client romances. The former opinion, 1987-2, did not ban such relationships, as you say, unless they were coerced or considered a form of payment for legal services. There are so many problems that can arise when a lawyer engages in intimate relationships with clients. Think about the issues concerning confidentiality, consent, undue influence, breach of trust, the myriad conflicts that can occur. Like the workplace romance between two employees we discussed in slide number 5, the lawyer-client romance will often end with one party feeling slighted. That can create divided loyalty problems, distrust among fellow lawyers in the firm. Even though the attorney-client relationship might be consensual, it can turn sour and leave the firm vulnerable to lawsuits for harassment, breach of trust, and other issues. So stay away from it.
It's not a good idea. Well, and as you mentioned, if you think back on the Weeks case, as we just discussed, if it had occurred now, the ethical obligations of members of the firm observing the behavior or even hearing about the behavior would be implicated. And so that if you even observed, well, under the former rule where it had to be either coerced or a form of payment, even that would cause a problem, because those would have been illegal under the Weeks decision and the general rules. So that there would now be all sorts of complications with reference to the reporting of this sort of thing. Justice McBride, in our last presentation of this discussion, pointed out that it happens, I wouldn't say frequently, but it happens in criminal representation in a fairly uniform way, where the spouse of a defendant represented by an attorney becomes involved with the attorney. And so think about that. One is in prison, the other isn't. One is being represented. It's just a real mess on the criminal side as well, too. So not a good idea, but probably we're going to continue to see problems with reference to that. And there are a lot of other problems as well. Let's go to the next slide. Because as you see from these hypothetical bullet points, it's not just between the parties. It involves maybe the clients of participants in the intimate relationship who have roles in their various companies. So take a look at these three problems or conundrums that are presented. Lawyer has a pre-existing sexual relationship, so that's okay under the rule. And the relationship is with a lower level employee with a big corporate client who doesn't have any, he's not part of the legal affairs department. And the firm takes over the representation of that corporation after they've started their relationship. So there wouldn't be any violation under the corporate rules of them having a relationship, but what are the ethical obligations? And that may be clear at the outset when they've first joined and the lower level employee is not in control of any legal affairs. But then bullet number 2, he gets a promotion and is promoted to be a special assistant to general counsel, and henceforward will be involved in all legal matters for that particular client. So what do you do? Also, what do you do if you simply are the associate attorney who's the friend of the involved attorney in your firm who's involved with the paralegal or whoever it is at the client, and nobody else in the firm knows, but you now know that there is this potential for disclosure of confidential information, conflicts of interest, and other problems. So what should you do under these circumstances? Any comments, Ming?
Well,
other than don't do it.
I would think that regardless of what the employee does, the lawyer representing the corporate client has a legal obligation to reveal the relationship to the corporation's general counsel, reveal the relationship with the employee due to the obvious conflict that the relationship creates. Rather than disqualifying the firm from representing a major client, which is one option, perhaps the corporation's lawyer can disqualify himself from representing and creating, well, remember they used to call it the Chinese wall? Well, I wrote an opinion when I was on the Court of Appeal objecting to that term. So we're not going to use that term. I use the cone of silence within the firm to keep confidential any information the firm receives from the client. So I'm not sure that that's the client's, that the best interest of the clients is served with that arrangement, but that's certainly one possibility, create a virtual wall or a cone of silence, but there are no clean solutions to this problem.
I remember how pleased I was when you came out with that ruling and thinking that you were the only one that could get away with it, probably, to write the opinion about the Chinese wall. But take it back to my last comment, though. Think about it. You're the friend of an associate who's the one who has the relationship, and you are aware of the potential problem and may be required under the rules we were discussing up above to report that to somebody as an ethical problem, not just as a company problem. And the potentials here are pretty grim. As mentioned, the disqualification of the entire firm representing Megabucks Inc. Because of the failure to take care of or deal with this problem in some fashion by reporting it and making it clear to the client are enormous. So this puts a heavy burden on lower level attorneys, not just the partner types like the man in Rowena Weeks versus Baker McKenzie, but this spreads the responsibility a lot further. And the former rule regarding initiation of disciplinary proceedings, which was 2-400, was weaker, as we pointed out, than the current rule. You don't have to wait till somebody complains about this problem. The state bar could get involved immediately and initiated a disciplinary proceeding under the right facts. So it's certainly something that everybody needs to be mindful of in the context of this new focus on speaking up and being responsible up the chain of command. Let's try the next slide. Now, of course, we've always in the rules emphasized the second requirement of attorneys practicing competently, which is one reason why we're here today, is to have continuing education on the competency of an attorney, both in terms of ability to perform and also in terms of performing the rules. So the duty to practice competently is one of those 3 C's we mentioned, and is one of the fundamental and most important aspects of the attorney-client relationship. But the new rule 1.3, I'm sorry, adds an additional duty of diligence to the competency requirement, suggesting that there has to be reasonable diligence in order for the client, in order for the attorney to have practiced competently. And as we all know, there's a lot of delay in legal proceedings. So this opens up an inquiry that will be interesting to everybody, because it differs from the former rule and the model rule, which simply state that you have to be reasonably diligent and prompt. Here, though, you can see that there may be a dispute over what diligence is, if it's reasonable speed in the production of legal documents or pursuit. Justice Chin, how do you think this will affect the practice in the civil world, where somebody comes into your law and motion court and says they want sanctions because your opponent is lazy and hasn't kept up with the case? What do you think will happen there?
It depends on how lazy they are. Well, Rule 1.1 emphasizes the requirement of a lawyer's competence, as you mentioned, Jim. 1.3 says a lawyer shall not intentionally, repeatedly, recklessly, or with gross negligence act with reasonable diligence in representing a client. What is reasonable diligence? It shall mean that a lawyer acts with commitment and dedication to the interests of the client and does not neglect or disregard or unduly delay a legal matter entrusted to the lawyer. With the addition of this rule, the 2 duties of diligence and competence become equally important components in a good lawyer's practice. Before the new rule, the effect on, I think, civil practice should be positive. Lawyers are now aware that they cannot ignore their clients' concerns about their case progress and are more likely to keep clients apprised of in real time about what is happening in their cases. Now, we live in an electronic discovery, age, electronic discovery. Lawyers must be especially diligent about document production and meeting deadlines. Whether a lawyer can be sanctioned for being lazy presents an interesting question. So I'll open with my opening remarks. What's the degree of laziness and the reasons for it? Not returning telephone calls in a timely manner, failing to inform a client of a court date can rapidly morph into sanctioned territory for lack of due diligence and perhaps even negligence. So don't be lazy.
Yeah, and my comment would be, and obviously I usually introduce myself to my new lawyer friends by asking if I sanctioned them but they remember that. But this sort of behavior was probably subject to sanctions simply because of the nature of the behavior. In other words, failure to respond to discovery or something at great length, that's covered by other sections. But there's another hook, though, in that you can't, remember, you can't threaten your opponent in a lawsuit with either criminal or ethical violations under certain circumstances, because that itself is unethical. So I think the answer will be pretty simple in the long run, that the underlying reasons for the laziness will be the dispute, and there will probably be means to justify sanctions for that. So if anyone is hoping that they can jump on to the new rule as a way to spur or encourage their opponent to move more quickly, probably has the tools they need already. Let's try the next slide. This is, as I discussed, the additional question about the interplay of competence and diligence that Justice Chin mentioned. I don't think we need to consider that anymore. We've already commented on that. Anything else you'd like to add, Ming, before we move on?
Well, on this slide, maybe we should talk about diligence a bit. You asked whether a lack of diligence is an ethical violation of an opposing attorney. I can think of some examples, but one of the first that comes to mind is a lawyer who fails to use technology and discovery and delays the progress of the case. We now live in a age of electronic discovery. So would refusal to use such discovery amount to negligence that is subject to either a private admonition or more severe sanctions? Certainly unreasonable delays in meeting discovery deadlines or filing numerous continuances or requests for extensions as delay tactics should lead to first an admonition and then more serious sanctions if the problem is not remedied. Such delay is probably a violation of Rule 3.2, which provides that a lawyer must not prolong proceedings at unnecessary expense. Remember, we are concerned with the client's best interest, and unnecessary delays due to an attorney's laziness or other problems violates the due diligence requirement. A related question is what diligence is required when an attorney discovers the falsity of testimony. If you suspect a witness is going to testify falsely, and they do, you should stop it. Rule 3.3 states that a lawyer must refuse to offer evidence that the lawyer knows to be false, regardless of the client's wishes. Lawyers have an obligation to prevent the trier of fact from being misled, and will be sanctioned if they knowingly allow false testimony to stand, if they become aware of it, if the testimony is dubious, but not knowingly. If it may be, what if it's dubious but not knowingly false? That presents a closer question, and the lawyer's obligation to protect his client comes into conflict. So lots of different issues.
I think it's going to be probably a question of degree, and then we'll have a line that goes from ordinary procrastination to negligence. And most of these discussions will fall somewhere in the middle there. So it will be difficult to decide exactly at what point it's a problem. It's worth mentioning that's in bullet 3 there, that this may implicate yet another problem, which is presented by the fact that there are, at the last time I checked, 129 lawyers in California actively practicing who are over 100 years of age. Reading that, in addition to looking in the mirror, reminded me that we're
getting closer.
Yeah, we're getting closer, and we have an aging population problem in California. And sadly, I've seen this in some of my mediations with well-known lawyers, but certainly lawyers that I've known for many years, who have probably taken one case too many, and they've ended up in a mediation on a malpractice case with me because of their declining competence that they didn't recognize. Remember the rules we're talking about here, that their colleagues possibly recognized and didn't report. So there may be a coming time when we have to think a little bit more about our senior partners and our colleagues who may be a little bit longer in the tooth. Of course, it doesn't have anything to do with age. I want to defend us old guys that we're still doing pretty well out here. It could also be early onset dementia. It could be other health problems, could be brain problems. There are a lot of things that could come up with reference to competence. Traditionally, we had the problem of alcoholism and drug abuse problems, possibly mental health problems. So under the new rules, you're really going to have to kind of keep an eye on your partners, and you're doing them a favor if you do, or your co-practitioners. You're doing them a favor if you do that. So some sort of intervention may be necessary. But once again, if diligence is a problem of competence, which would put us on the end of the spectrum towards negligence, you're going to have to do something. And that isn't really much of a change, but it's simply a lot more clear now that you have to do that and that it extends throughout your firm. So let's try our next slide. Well, Ming, you and I practiced for many years using the checklist approach, which was used to identify conflicts of interest. And I know because of your Chinese wall case that you have some comments on that, and I suspect that that your colleagues on the Supreme Court considered that issue as well. So what your comment with reference to Rule 1.7 be in terms of moving away from the checklist approach to something a little more complicated?
Well, Jim, as you say, the old checklist approach has taken on some new meanings. New rules 1.7, 1.9 use the term adverse, directly adverse, and materially adverse when referring to a client's interest being in opposition to clients or former clients' interests. I am not quite sure if we can quantify the 3 levels of adversity. Other new rules codify the common law imputation principles, including those governing lateral hires under Rule 1.10, and screening of government lawyers joining private practices, Rule 1.11. What remains important in each of these rules is the client's best interest. So use your judgment to determine whether you should disclose any perceived conflicts.
And behind the scenes, I was friends with members of the committee that were drafting the new rules for over a decade, over 2 decades, actually. And I know they went round and round about this at great length over trying to figure out the difference between the directly adverse and materially adverse. But I think Justice Chen is right on the money by saying, think of the client. That's number one. If the client could be damaged by this, and even if you want to keep the client, you should think carefully about the ramifications of not considering the potential conflict of interest, because they can be devastating, obviously. Again, in a case that's important to the law firm or to the practice, and late in the game you discover the conflict, you know what can happen. So pay close attention to that one.
Jim, I was also involved with the people that actually worked on this, including Justice Lee Smalley Edmonds. In my conversations recently with Lee, she reminded me that a lawyer from the Supreme Court Central Staff, whose name is Greg Fortescue, was deeply involved in drafting these new rules. When it came time to draft a chapter in my Rudder Group employment practice guide, we drafted a specific chapter on professional responsibility, and we got Greg involved in drafting that chapter. I commend it to you if you want a short version of. There's a 2-volume Rudder Group practice guide on professional responsibility, which is excellent. But if you want a shorter summary of that, go to Chapter 2 in the Employment Litigation Practice Guide. End of advertisement.
I think I probably see the binders behind you on your shelf there as well.
I do have a few of them.
Yeah, again, underlining how happy I am to have Ming with me this morning. So let's shift to our next slide and talk about how you safekeep your clients' funds. Well, mishandling of the money is still the #1 problem that results in discipline. The thing to remember about all fees matters is that the fees are held in trust. So once again, we're talking about a fiduciary relationship that is very important in terms of putting the client's interests first. We need to, in case anybody doesn't know it, distinguish a couple of things. One, the classic retainer. We all, I think, kind of use the term retainer perhaps a little loosely in its classic sense. Originally, it meant that you paid for a block of time and you got an attorney for all of that time. So you retained somebody to be always available to you for a particular length of time. That's morphed a little bit now, so that we generally talk about retaining as just being hired. But in terms of the funds, it's a little bit different. The emphasis has to be on safekeeping of the funds, and it not only involves the care and safekeeping of the money and property, but also involves safekeeping of the client's electronically stored data. That can include trade secrets. In the medical field, the HIPAA requirements kick in so that you may not appreciate it, but if you, for example, have for example, this has come up from me, an arbitration in a law office where the medical records are going to be used as exhibits. And in a week-long arbitration, you are leaving those exhibits, which are medical records of the parties, in the conference room. Is that potentially a problem if the janitor comes in and moves them around, or, God forbid, rifles through somebody's medical records and results in a HIPAA violation and complaint? So, and you can conceive of that being particularly important in the case of a celebrity case or something that involves files that would be confidential, or just, business intrigue where a mediation involving a particular trade secret is going on, or an arbitration, and somebody wants to sneak in and take a look at the files. So that obviously can result in considerable liability on the part of somebody who gets caught in that net. So my own advice is to not only, of course, keep close track of the money, and there are a lot of ways to make sure that's done properly. Obviously, the problem of disputes over whether or not an attorney has mishandled the money frequently include disputes with the client over how much was withheld for either contingency fees or for costs. I've seen a couple of those cases in mediation already. So you don't get in trouble if you're ultra careful. And it again leads us back to saying that the client's interests have to go first. And at every point, even considering the idea that you've left trade secrets out in the open during some sort of a session, that continues to be the focus of the attention of the rules. You got to make sure your clients are protected. So it can only come back to bite you in the potential negligence case if you haven't done that. You have any comments on the rule, Ming 1.15?
Well, Jim, your advice is, as always, sound and logical. The new rule 1.15 focuses on advance fee deposits and maintaining a client trust account. The rule makes it clear that it applies to all clients' funds received and held, meaning that those funds received before the rule's effective date are included. The mishandling of a client's funds and property remains the number one, I repeat, the number one complaint against lawyers. Do not make the mistake of treating these funds like your petty cash. Do not treat these funds as a source of a loan that you may repay someday. You all know what happens when you do that. On the related subject, the emphasis on safekeeping of clients' funds and property not only involves the care and safekeeping of funds and property, but also involves maintaining a client's electronically stored data, including trade secrets, HIPAA data. The safekeeping is especially crucial when you have multi-day hearings or meetings that leave client information exposed to others. Leaving confidential information like trade secrets or celebrity identities for others to see can end with a client who sues the attorney for failing to secure private information that is left behind on a depositions room conference table. The key to all of this is maintaining client confidentiality. New Rule 1.18 codifies the common law rule on this point and ensures the lawyer's duty of confidentiality even when dealing with prospective clients. The same rule applies to mediators and arbitrators who must be especially careful not to receive confidential information from any of the participants and without opposing counsel's knowledge, reveal it without counsel's knowledge, without client's knowledge, revealing it to the other side. So confidential information is that. It should remain confidential, and you have to exercise prudent judgment in making sure that it is protected.
It's worth mentioning that the mediation privilege would protect a mediator or an attorney under some circumstances, but you have to consider the possibility of industrial espionage. So beyond the idea of whether or not it could be used as evidence improperly, is the problem that it could be, the basis for a huge dispute over some new computer program or something like that that became public knowledge outside of an otherwise confidential proceeding like arbitration or mediation. So I have deliberately avoided getting too much into the liability of mediators with reference to this this particular rule, but we need to remember that we are practicing lawyers, and not a lot of attention has been paid to mediation other than Evidence Code 1129 and the revisions to that. But there are potential ramifications to disclosure that aren't necessarily covered by any opinion at this point, because they haven't come up in terms that can result in some sort of discussion of that. But I think as active lawyers mediating, we also have to consider all of these rules as well. Let's go to our next slide. This one, we've called the favorite ruling among judges, but I think the emphasis of it should be that there are concomitant interests in the court. We've focused on the fact that the lawyers have to pay attention to their client's interest first, and that relationship that has the 3 C's is the fundamental basis of the relationship between an attorney and a client. But there's another entity with a dog in this fight, and that is the court. The court cannot function under circumstances where lawyers are behaving unethically in the sense of the candor to the tribunal. So the earlier opinion that we mentioned up above, 2019-200, posed that question of what your duty is towards the tribunal, that's the court, and it would include the arbitrator as well. So obviously, I think everybody probably knows that a lawyer is not supposed to knowingly make a false statement of fact to a tribunal, or, and this is important, failure to correct a false statement. And I think we've gotten this in our practice and in our time on the court, where it has happened that somebody has immediately said, well, wait a minute, that wasn't true, and we want to correct that. It's rare, but it is required, and it was always required. But this Rule 3.3 raises a couple of more questions about what happens in various scenarios. So this one, I know that Ming, you liked, because I did too. Once we got computers up on the appellate court bench, we could check the citations in real time. And I remember how delightful that was to discover that a lawyer had overlooked one of Justice Chin's opinions that was published 2 days before the oral argument in my court. That was a slam dunk. Or more troublesome, the situation where there's adverse authority that we're aware of, and that's what I used to warn people from the bench. I got my computer right here, and it says that what you just told me is not right under this following case. So if you do that knowingly, you can get in a lot of trouble, and you also need to disclose it to your opposing counsel to make sure that we're all on the same page with reference to a misquotation or a miscitation or an adverse opinion that's either recent or just unobserved by the court. I think probably you'll need to explain that to your client too. I mean, it would just be good practice. I think if you get yourself in hot water like that, it's probably better not to do it in the first place, but it could reach a level where your client needs to know too. And I don't think you're going to want to call them up and say, I gave the wrong facts to the court. But then number 3 bullet tells you the other problem. Your client's not telling the truth. And what do you do with that? Justice Chen, have you ever encountered a witness who might not have been telling the truth in your trials?
I think the closest it came was a witness asked me what his answer should be. And I said, I'm sorry, it doesn't work that way.
Right.
So I will get you another lawyer. But this rule 3.3 is certainly important to judges. It requires a duty of candor on the part of lawyers to courts. A lawyer cannot knowingly make false statements, fail to disclose adverse legal authority, and or misquote the law, or offer evidence the lawyer knows to be false. Those are obvious, but these rules that discuss a lawyer's duty to the court are like the rules that apply to compliance, where the misbehavior occurs in a lawyer's law firm. So these things are obvious. I, Jim, don't recall having a witness testify falsely and having to correct it. I think you have to do that if it happens. In the 3 hypotheticals suggested in this slide, when a lawyer suspects a client has lied in the deposition under oath, or after the evidence has been presented to the court, I think the lawyer has an obligation to correct it. The close call between a lawyer's ethical duty to the client and separate but equally important ethical duty to the tribunal to be truthful. When a lawyer has actual knowledge that a client has committed perjury or submitted false evidence, the lawyer's first duty is to attempt to convince the court to voluntarily correct the perjured testimony or false evidence, given the consequences. If the client insists on lying, so you got to correct it, or have them get a new lawyer. If that doesn't work, the lawyer, you have to withdraw. If you may be crossing some lines if exposing the lie will contravene the client's Fifth Amendment rights. So there are lots of considerations here, but I think the lawyer may try to convince the court not to accept the evidence. It's difficult if the court is the finder of fact, but if it's a jury trial, that may be a possibility. But as you know, that old saying, how do you unring the bell? If they heard it, how do they unhear it? So there are lots of problems here, but I think this rule that judges expect lawyers to be candid and honest with the court and in the testimony presented, that's essential to maintaining a rule of law that will render just findings for all concerned. I think our system depends on it. We should promote it. If it occurs, we have to correct it.
Yeah, I think that the takeaway there is certainly that the whole system will fall apart if we aren't careful about that. So the idea that, as so many questions end up being, it depends, is pretty clear here because of the ramifications of going forward with known improper testimony. Perhaps I was luckier than you, Ming, because I did have a case where I had actually it was two police officers who testified in a fashion that made it absolutely clear that they were perjuring themselves. And it was a criminal felony trial involving a drug arrest. And it was being tried by a law student who was certified by the DA's office to try the case. And I remember the law student who was trying the case really turning pale when he heard the second officer testify that no, we weren't going southbound, we were going northbound, and it was daytime, it wasn't nighttime. It was a story for another day how that got sorted out, but it was obviously a terrible problem, and it resulted in obviously the dismissal of the case and a lot of problems on the criminal side. But that's just one example of what you can hear. In answer to my own question, did you ever see a witness lie? I would say that it'd be easier to list the people that I thought were entirely truthful, because I think it's difficult to testify for witnesses and get everything absolutely right. But the policy that requires you to let the court know when this has happened has always been important, and it hasn't been changed by this, but it has been clarified. So we would urge you to read the opinion that's listed in slide number 6 about this issue. It's number 2019-200, because it's something that we hope will not occur in your cases, but it might. And as always, these opinions have the last word that you should bear in mind. Another slide we mentioned earlier was that situation where you're in settlement negotiations, mediation, and the lawyer discovers that the client's case is no good, and can they withdraw, or should they withdraw, or how do they withdraw? Well, that would certainly include the case where you're in the middle of the case and you discover that your client is lying, is flat out lying. Question presented here, though, is can you go ahead and settle the case? Can you go ahead and just not mention it, settle the case, and then withdraw? And one of the earlier opinions, I can't remember which number it is, it's in number 6, I think, deals with that problem. But you have duties then related to that situation where you're leaving the law firm, where you may have continuing duties to the client that you're leaving, but you also have duties to the tribunal, which I guess would be the court, but you're in a mediation setting. So you got to think about that. It might be an appropriate off-ramp if you discover your client's lying, but like we said, it depends on where the lie takes place and who's being misled. It's safe to say, just like we concluded, it's probably not a good idea to have sex with your clients. It's probably never a good idea to know that you have told something untruthful to the trier of fact, the tribunal, or the court. Because I think we can guarantee that you're certainly going to get in trouble on that almost as quickly as you will under the circumstances of messing with your client's funds, which is number 1. So once again, you've also got a reputation problem there. You've got a problem of pulling in your co-practitioners. If they know about it, they have to drop dime on you. Remember 8.4.1. And remember 5.2, you're the subordinate lawyer. You know that your partner's client is lying to the partner. There are all sorts of ways that this could pop up. And once again, it emphasizes the rule that you are in a position, always in the position of looking first at the client's interest.
And I think, Jim, we ought to emphasize the part of this a program that deals with lawyers making representations about the state of the law to the court. And you and I particularly ran into that on the Court of Appeal and the Supreme Court on appellate matters. Lawyers spend a lifetime building reputations, and it's either good or bad. You can spend a lifetime building a good reputation and throw it down the drain by making a false representation to the court. You think about that carefully. Always be straightforward with the judges you're appearing in front of, making sure that you are giving an accurate representation of the facts and your best knowledge of the state of the law. Because if you're cutting corners, you start diminishing that fine reputation that you've built over so many years. That fine reputation can be gone in an instant. And judges talk to each other. All the judges know who the good lawyers are, who the lawyers are that you can trust in what they are arguing and presenting. So protect that valuable reputation that you've built up in the legal profession over so many years.
Let me emphasize that with a bit of a war story. My law and motion experience went on for 4 years, and doing the math, it was every lawyer in California showed up in my courtroom at some point. So out of maybe 25 or 30,000 motions that I heard, I can remember very clearly the names and the faces of 3 lawyers who lied to me. And that was 20 years ago. And yes, the judges do talk about those things. And I think might have been Abraham Lincoln that said that the only thing a lawyer has to sell is his or her reputation. And that's quite true. If you get the stink on you from that sort of thing, it will linger for a very, very long time. So there are reasons beyond just the ethics problems that encourage you to do the right thing here. I want to circle back too, because I had promised earlier that we would mention at least one case, and that was the rule that was rejected about representation of clients who might be demented or and otherwise incompetent, and how a lawyer has to behave in that. It's a very good opinion rule. I think it's 2021-207. And I'm not sure if I imagine that Lee Edmonds was involved in that. But it makes clear, as we discussed earlier, that there wasn't really a need for, and there isn't a rule that attempts to discuss that thorny question of what can happen when a lawyer essentially is called upon to act as an attorney in fact, an attorney de jure in a case. And that extends, if you read that opinion by the committee, to pre-representation as well, and to other issues that are unrelated to things like brain injuries or incompetence on that side. Increasingly, I think we're aware of mental health problems more than we used to be, perhaps. Actually, in law school, I took a course called Psychiatry in the Law, which was very interesting because it was taught by the guy who invented the Twinkie defense, for example. But it also pointed out that there are far more mental health problems in the general population than most people realize, and that courts and litigation are very attractive to people with mental health problems, such as, for example, paranoia. So there may be a need for you to kind of observe your clients here In addition to what happens when a client actually has a deterioration of competence to the point where it's difficult for you to deal with them. And the limits on how much you can help them. The case that I described earlier that resulted in the opinion was a situation where the lawyer represented a client in an injury case, traumatic brain injury. He was deteriorating, and he knew that he was ultimately not going to be able to make decisions. And so he wanted to authorize his lawyer essentially to take over that task. There are a lot of pitfalls in that, obviously, because that expands your fiduciary duty, even if that is possible, beyond where it was when you were simply the lawyer, and can get you into a lot of other hot water. But it also requires some finesse, which is why the opinion points out that the common law and the common law of California basically answers all these questions. But I would point out that if you read closely, they answer them in terms of liability. So in terms of ethics, it's maybe a different inquiry, but it also is going to go rapidly to the situation of liability. We didn't do a hypothetical on that, but you could easily think up one where the lawyer begins to manage the affairs of a client in a case and gets objections from the lawyer's family or from other interested parties under circumstances which can cause the whole thing to turn to a real mess pretty quickly. So when you're dealing with clients who are or may be mentally impaired in some way, you need to take an extra moment to read Opinion 207 and appreciate what that means in terms of your dealing with this particular client. Anything else you'd like to add, Justice Chin?
I don't think so. Oh, there's one thing that you may be wondering why these rules took so long. When I talked to Justice Edmonds, she said, the court gave us 3 years to do this. And she said to herself, how in the world is it going to take us 3 years to do this? And when she got into it, she said, oh, no wonder. So it was a mammoth job. Lee, as usual, did a wonderful job of pulling it all together. But she did credit the Supreme Court attorney, Greg Fortescue, for doing a lot of the legwork in putting all this together. So when I needed someone to help drafting the employment litigation chapter on professional responsibility, we drafted Greg, and he did a terrific job. The professional responsibility practice guide is also well put together. There is even a group of documents at the end of it, and one of them is a comparison between the ABA model code and the code that was adopted by the commission. So it was a difficult, long project, but I think Justice Edmonds' final product was very helpful for the court. I remember reading Jim's first slide when I got involved with him putting this program together, and he had something on the first slide that says in 2018 the Supreme Court finally published the
I emphasized it, all caps. Yeah. And no criticism was intended of either the court or the committee in that, because as I said, we were aware of that 29-year hiatus, and there was a lot of turnover and a lot of discussion of all these rules. And I think the result reflects that. because these rules are much stronger, and at least I'm more comfortable with them than the old ones. And then those of you who had a multi-jurisdictional practice will remember that you had to have a separate book with charts to show you the California rule and what everybody else did. And that was really cumbersome and difficult to deal with. So the fact that we're now essentially with the model rules brings us in line with everybody else, which is probably not a bad thing. But also these have been fine-tuned. And I think that's what we've emphasized here today. They've been fine-tuned to focus on some actual problems that came up during the past few decades. And to kind of close some of the loopholes that allowed firms and lawyers to not be as quick to deal with problems that were otherwise illegal or otherwise improper. And if you think about it, that just is good for the profession. We don't want to appear to be hypocritical at all with reference to the policing of our own ranks in terms of these rules. And as we began and where we will wrap up our presentation is to say that the fundamental nature of the relationship between clients and attorneys really cannot survive without confidentiality, because that's why the client comes to you and that's what the client needs. Without competence, because once the client comes to you, the client needs to be assured that whatever advice you give is going to be appropriate, and that it comes from a lawyer who's all there mentally and running on all cylinders, and that that lawyer is being supervised or is being observed by other lawyers to make sure that he or she remains competent, and that all lawyers involved in these processes are compliant with the ethical rules and the laws. So if you really think about that last term, the first idea that now you don't have to wait for a complaint from an agency to undertake an ethical investigation, you can begin right when the occurrence occurs. That is completely in line with the idea of compliance, so that lawyers in their firms must comply under 8.4.1 and 5.2 and the ones we've been discussing. They must comply just like everybody else was. And as the public might say, they have to comply just like we do, so that nobody's getting a free ride. Because when we were talking about the Weeks case, and Justice Chin mentioned, imagine what would happen today in front of a jury. Well, think about it. If jurors had an opportunity to take a shot at the law practice generally, they might do what they did in Rowena Weeks' case. And I think there was a little of that expressed in the jury verdict, which was so monumental at the time. I think probably we then have, unless you have any more comments, Ming, I think we probably have time to take some questions, perhaps. I'm not sure. Katie, have we collected some questions that we might answer?
Hi, yes, we absolutely have. So I have some questions here. Thank you, everybody, for submitting through the Q&A function. Something we got early on in the program reads, does the state bar's right to investigate discrimination apply to questions around jury selection?
I'll let Justice Chin take that one.
Thanks a lot.
Well, I would comment, I toss it to Justice Chin because the Wheeler case, both civilly and criminally, has bedeviled us for years in terms of what happens.
Jim is talking about the Wheeler case, and in jury selection, attorneys cannot challenge jurors based upon race, and you always get Wheeler motions when the prosecution challenges, say, a half dozen African Americans or half a dozen Hispanics or a half a dozen Asians. And then the other side, the person who makes the challenges has to justify them and state on the record why they were made and that they were not based upon race. But these Batson Wheeler questions are litigated and litigated extensively, particularly in death penalty cases. The question is whether or not, if there is an abuse by an attorney over a number of cases, could that possibly result in a state bar investigation? Maybe. I'm not aware that it is happening. I'm not aware that anyone has been brought to the attention of the state bar for continually violating a defendant's rights to a fair selection of a jury. Certainly, if that occurred, I don't think it would be an impossibility, but I don't think that I'm aware of that it's happening.
Well, I think the import of the question is interesting because it suggests, as our earlier discussion, do you now have an ability to report an ethical violation by a lazy attorney? Do you now have an ability to report in your civil case an ethical violation that you lost because he only had women on the jury and it was a sexual harassment case or something like that? I think it's unlikely. It would be difficult, I think, probably to prove it, and that's proved to be the problem in the Wheeler-Batson situation too. There's so many moving parts in the selection of the jury that it has to be a pretty clear violation.
And you would always raise the question: would an attorney really be that stupid?
Yeah, yeah, exactly. And on the other side, the attorney saying, well, I had lots of reasons for this particular person, not just that they were of a particular race. I remember picking juries in criminal cases where I couldn't tell. I'd look at the jury pool and they looked like the United Nations, and the guy would complain and I'd say, well, juror number 3 appears to be a woman of color. I don't know what your objection is. So there are a lot of moving parts when you make that sort of complaint. And I think I agree with Justice Chin. It could be a violation, but it probably would be rare.
Mm-hmm. Yeah, thank you. To pivot to some of these questions related to ADR practice, pertaining to your final slide in Rule 3.3, requiring honesty to the court, does that also require honesty to the arbitrator if it matters in arbitration?
I think it does. The more interesting question, though, is that does it apply in the mediation sense? Because the mediation, the policy with reference to mediation is it remain completely private, so that the parties will work on resolving their case. But then we had, a big dispute or debate a couple of years ago over changing of those particular rules because of the potential that malpractice occurred during the mediation. Mediators were very alarmed by the prospect that they would be called as witnesses to that potential. So that particular problem was dodged, but the problem of what happens in the mediation, which is by its nature sometimes closer to a poker game than a hearing of fact, in terms of what the claims are and the allegations and the demands. But I think it potentially could even arise in mediation. But I believe it would certainly occur in terms of arbitration, and certainly in private trials as well.
I don't think there is an opinion on it yet, but I'll give you one.
Okay. And I'll give you a second vote. So we at least got to the Supreme Court level.
Mediations depend on the mediator getting all of the facts, not half-baked facts, not made-up facts, not a law that you want it to be, but the law as it is. If you do not give that to a mediator, you are jeopardizing that mediation. Getting people to agree on a compromise involves trust. And I think part of that is that the mediator trusts the parties who are talking to him or her, giving them all of the information they need, and the mediator giving the parties their evaluation of the law based upon those facts. If you're not giving the mediator an honest representation, what are you doing?
You're quoting me because it did occur in one of my mediations that I said, you're wrong. That case doesn't say that. Why are we here if that's the basis of your claim? So it's a kind of a practical problem in mediation. I mean, you're wasting your time if you're not telling the truth, and you're annoying the hell out of me. If you're trying to, you shouldn't try to blow smoke at the mediator. It's not going to help you ultimately. But I think you agree with me, Megan. In arbitration, certainly it's true because it's a tribunal situation.
Absolutely true in arbitrations, but I just wanted to put an exclamation point on the mediation process.
Yeah,
it collapses if you're not giving accurate information.
Yeah, context is everything, and in the context of mediation, you may not be subjected to an ethical dispute, but you're certainly wasting everybody's time if you're not well prepared. Any other questions, Katie?
Yeah. Building off of that, if as the mediator, would the rules speak to any obligation if you find that one of the attorneys involved in your mediation committed misconduct during mediation?
I was afraid you'd ask that. I was afraid somebody would ask that because I had a case not too long ago where it was clear to me that one of the attorneys had committed malpractice. And this is a real practical problem for a mediator because one of the most difficult things we do is to not interfere with the relationship of the clients and the attorneys. So the reason I was hoping you wouldn't raise the question, because it raises the question of the ethical obligations of a practicing attorney, me, as a mediator, to speak up. My conclusion in that particular case, where I had no doubt, and the opposing attorney also had no doubt about the malpractice committed by an attorney. The opposing attorney, of course, was under the rule saying that he couldn't threaten his opposing counsel with criminal or ethical violations as a means of negotiation. But the duty of the mediator under those circumstances where the observation is made is a lot more difficult to cover. In my case, I satisfied myself by an understanding that the opposing attorney knew about it and that there was, thankfully, in that case, already a suggestion that there was going to be a change of counsel. So I didn't feel like I needed to report it, but it troubled me a great deal to observe an attorney committing malpractice in the mediation. And those cases do pop up, which is why we had the argument over the rule about whether or not a mediator would be could be forced to testify about what was seen. Now, in my particular case, it wasn't a mistake during the mediation. It was observing that things had been done outside the mediation that had made the situation a lot worse. But that's something that is troubling for mediators as well. And I think we do have some duties there, but at least in terms of our former rule, we probably are not now in a situation where we have to report anything.
Jim,
I should ask the Supreme Court about that.
No, I agree with everything that you said, but I'm going to give the audience a reason not to do this, not to make misrepresentations, not to misrepresent the facts. Mediators talk to each other. The attorneys on the other side talk to each other. If you think you're going to get away with that, the world is going to know about it before you turn around. So don't do it. By all means, don't do it when you mediate in front of me. You will not find a happy mediator. I think it's goes back to that question of your reputation. You build it every day that you're in practice. You can blow it away in an instant if you start making misrepresentations to a mediator, an arbitrator, or whoever you're trying to convince to help you resolve your case. Oftentimes at the Supreme Court, we would look at each other and observe the activities of a particular lawyer and asking each other on the court, should we report this to the state bar? So keep in mind those conversations take place. And mediators do talk to each other. It's not going to be a secret.
Yeah, I used to tell people that when something happened in the Alameda County Superior Court, I heard about it within 10 minutes in San Francisco, including the behavior of lawyers. And it's certainly true that the mediators talk as well, too. That particular attorney that I mentioned is on my list. I don't work with him anymore. I haven't badmouthed him, but I certainly don't want to work with him again. Well, I want to thank you, Ming, for helping me out here. It was a lot more enjoyable to do this than my first time, or I wouldn't undercut the second time because I did that with somebody else. But this was a particularly good session.
It was my pleasure.